Hello everyone, I'm Stewart Dresner, founder, chief executive of Privacy Laws and Business. It's a pleasure to have you joining us from around the world. Welcome to Meet the Regulators in South Africa and Mauritius, requiring companies to comply with their data privacy laws. Before we get to the session and introducing the speakers, I'm taking this opportunity to tell you about PL&B's international report, available in paper, PDF and online formats. We report on over 150 countries. In the February international report, we published tables on 145 data privacy laws and 23 bills. In the April edition, published last week, we covered Singapore, Vietnam, and how Coca-Cola is complying with the GDPR. Full information on both reports is on our website, privacylaws.com. We've also released 14 podcasts under the name Privacy Pass. The most recent one is on AdTech, and our podcasts are available also on our website. Now, turning to this video, this session today, a recording of the video of this session and the slides will be available to you from tomorrow. If you've got questions to the speakers, please type them in the Q&A session at the bottom of the screen, and Laura Linkamis, the editor of both reports, will watch as they come in and respond to you or put them to the speakers at the right time. Don't wait until the last few minutes of the session. Now, details of the speakers are on our website, but I would like to introduce them now. First of all, Drudeisha Madhub, you have been your Mauritius Data Protection Commissioner since 2007. And you've ensured that Mauritius is a member of many international networks. The details are on our website in the biographical section of this session. You're also a United Nations Emeritus expert, joining the UN Global Pulse Data Privacy Group in 2014, and you had the honor to host the Data Protection Authority's own annual international conference in your country, Mauritius, in 2014. I'm now going to turn my attention to Lebogang Stroom-Nzama, advocate, and you are a full-time member of South Africa's Information Regulator, and you've kindly allowed me to use the short version of your name, Lebo, which is much easier for me. You have 2 law degrees, have worked in a law firm, and your previous jobs have involved legal compliance and risk at various financial service institutions. You're an advocate of the High Court of South Africa, and a member of the Johannesburg Bar. Now, at the Information Regulator, you have specific responsibility for the law on access to information, and you are taking over responsibility for this subject from the Human Rights Commission. Now turning to Professor Sizwe Snail Ka Mtuze, and you are a member of South Africa's Information Regulator also, and you also have 2 law degrees and are an adjunct professor in the law faculty of Nelson Mandela University. You also are an author and editor on IT law and cybersecurity, and find time to run your own law practice. I was fortunate to meet both of you, Lebo and Sizwe, at the Privacy Commissioner's annual conference in Hong Kong in 2017. So this has been a bit of a reunion in a sense, and that's great. Now, Privacy Laws and Business in our international reports have covered the development of data privacy laws in South Africa since 1997 and in Mauritius since 2011. So we have been watching, but I became particularly interested in African developments when last year I chaired a session at the CPDP conference in Brussels, where the speakers included data protection commissioners from Burkina Faso, Ghana, and Morocco. And on Data Protection Day on 28th of January this year, I attended a Council of Europe online session on Africa, in which Drudeisha and Sizwe were speakers. Mauritius and South Africa are on the shortlist of leading African countries with both data protection laws and data protection authorities. So that means your governments are serious about implementing the data protection laws. Multinational companies outsource their operations to these countries, which are relatively prosperous in Africa, so represent important markets. They are both countries for outsourcing from other regions, so companies need to learn about their data privacy legal duties in Mauritius, where the data privacy law has been enforced for several years, and South Africa's law, which will enter fully into force on 1st of July this year. So we'll start with an introduction from Mauritius from Drudeisha, and then follow from South Africa, and then we'll follow with questions to each jurisdiction in turn. So we'll start with you, Drudeisha, on your introduction to data protection law in Mauritius.
Hello, everyone. I'm very happy to be here today with you all. And it's really indeed a privilege to be talking on this forum on Mauritius and South Africa as well. We're not competing together, Mauritius and South Africa. So it's just, I think, very nice initiative from Privacy Laws and Business to gather these two countries on the same platform and to show you how we've been able up to now really to make data privacy one of the most important concerns with regard to economic prosperity and fundamental right to privacy. So thank you again. Just if I may, my first slide. Is it possible? Yeah, thank you. As you can see on the first slide here, where Mauritius is located actually, the first one, the second one. Yeah, okay, great. So as you can see here, it's a small dot for those who don't know where Mauritius is actually. It's on the right-hand side of Madagascar. It's really a small country with around 1.3 million people. But don't be, amazed by the size of the country and the amount of people that actually lives in that small island. We have a reputation of being, if not the prime, but one of the biggest leaders in Africa. And we have many functions, many companies here which are investing hugely. And Mauritius is a democratic country. It's very stable, and harmony is prime here. It's a peaceful country. But we have so many diversified sectors here: offshore financial activity, textile, medical tourism, outsourcing, BPO, KPO, LPO, new technologies, AI, and the luxury tourism industries as well. So these are the growing sectors of the economy. Next slide, please. Now I will just go straight in the Mauritius Data Protection Act. As you can see here, there was a first act which was enacted in 2004, but which came into force in 2009. I was actually recruited in 2007 as a consultant to set up the Data Protection Office. And that was my mandate for a 2-year period. And after that 2-year period, I actually put that law into force in 2009. And then we started operationalizing the functions of the office, and it became permanent. And I stayed as commissioner in that office since, let's say, 2009. So as you can see, I'm still in that function up to today, and it's been already 13 years that I'm the commissioner for the office. It's a public office. And 2017, we decided to amend the Mauritius Data Protection Act. That was to align with Convention 108 and the EU General Data Protection Regulation and some other international standards as well. So on the 15th of January 2018, it came into force. And I must say, I'm quite proud of this piece of legislation. It's very simple, and it's just like Convention 108 Plus. I will come into detail on that. And it's very user-friendly. We've got principles which are completely aligned with the EU GDPR. And the main rationale behind this new piece of legislation was actually to regulate the processing of personal data like any other data protection law, but also to enhance the functions, the powers, and enforcement of the legislation, which is really very extensive if you go through the Data Protection Act. But as I said, to align with international standards, and that was actually the biggest achievement that we've been able to make up to now with the Data Protection Act whilst we operationalize it. Next slide, please. I just wanted to give you a panorama between the Mauritian Data Protection Act, the General Data Protection Regulation, and Convention 108 Plus as well. In our law, we have the requirement still, mandatory requirement for registration of all controllers and processors operating in Mauritius. And that is not the case, as you can see, in the GDPR, but we maintained it. It was here in 2004, and we maintained that requirement of registration. Why we decided to demarcate from the EU GDPR in that perspective was we found during, on the ground, that it's very important to be able to monitor the situation, not always going for site visits, inspections all the time, but registration is for us, one of the most efficient ways to be able to know actually what a company is basically doing with data, even though we haven't met that company or that controller or processor in person. So it's really important for us, and we maintained it. As you can see in our law as well, any breach of the Data Protection Act is actually an offense, and an offense which is prosecutable. So there is a criminal sanctioning system here in the Data Protection Act, and the maximum fine is 200,000 rupees. Maximum imprisonment is 5 years, actually. So that was what I wanted to highlight. But compared to the EU GDPR, it's actually the administrative sanctioning system, as you all know. But for us, it's an add-on. That is, it's still possible for someone to be prosecuted under the Data Protection Act, and at the same time be civilly sanctioned before the Supreme Court under the Civil Code, where there is a specific provision on the right to privacy, and they can actually do that as well. On top of that, administrative sanctioning is another level of sanction, which is also possible through judicial reviews before a Supreme Court, etc. So this is what I wanted to say. I think there is an error here on the maximum fine. Actually, the maximum fine is 100,000 rupees. I'm sorry about that. And then we go to Convention 108 Plus. As you can see in Article 12 here, and we fully comply with this. I will tell you why later. There is a provision which says that the possibility for judicial and non-judicial sanctions to be considered effective remedies. And in our case, it's judicial, that is criminal. And in the case of the GDPR, it's like a little bit of non-judicial, meaning administrative sanctioning by the data protection officer of a supervisory authority in the country. So this is what I wanted to highlight. Next slide, please. So we basically have a very important task here. If you go through the Data Protection Act, you will see lots of functions. But we do a lot of sensitization campaigns. In Mauritius, I go on TV. I mean, that is all where in all countries we do that. But we also try to be innovative in the sense that we offer in-house trainings at this office. Up to now, we have trained around 350 data protection officers who operate in each organization. And it's mandatory in Mauritius, it's provided in the Data Protection Act, to have a data protection officer. Every organization, public or private, must have a data protection officer. And we train these officers because we know how difficult trainings are otherwise. So we train them and they get a certificate, and then they go out and they train the members of their own organizations. We regularly publish guidelines. There are around perhaps 20 guides, comprehensive guides that we have published on each thematic theme for data protection issues, which are trendy. For example, last year, we published privacy and virtual currency, which is actually fintech, is a very alive thing happening in Mauritius. And national security and privacy as well, because we had some issues with safe city and smart cameras being everywhere in Mauritius. We have smart cameras now. So we published one on national security and privacy. Again, it's very comprehensive and it helps people to understand how to navigate data protection issues across. We have been, as I said, very innovative. We have produced a data protection training toolkit where actually I, myself, and my staff to a little extent, we teach, we train as to what data protection is about on each and every aspect. It's around 3 hours training, and we give that freely to all controllers and processors. It's also available on the website, so they can self-train themselves on data protection. This is to avoid that we actually have mass trainings being done at the level of the office. So this is how we are trying to educate our population and controllers and processors in Mauritius. I think I will stop here unless you want me to continue, Stewart.
No, thank you. That's a very fine overview and introduction. And it's interesting when you talk about registration, not in the GDPR, which you are correct, but in the UK, or even the UK has brought back registration, even though it wasn't officially in the GDPR, it's there. And as you say, it's a very useful tool to achieve a census of who are all the organizations processing personal data. And so it's worthwhile to have that thing. Now, Laura's appeared on the screen. Laura, our editor, do you have a question you wish to raise?
It's a question from the audience actually on the point of registration. Does the registration requirement apply to sub-processors in Mauritius, even if the processor is not based there themselves?
So we have to make the distinction very clear. I mean, if you are a processor in Mauritius, means you have to be incorporated in Mauritius as a company, as an organization operating in Mauritius. So we register only those who are operating in Mauritius, who have been incorporated in Mauritius, because the Data Protection Act does not have extraterritoriality application like the EU GDPR. We are concerned with those who are established in Mauritius. And I will come back to this point later if you allow me to explain in the Data Protection Act what establishment actually means.
Right. Okay, you've answered that question very clearly. Thank you, Laura, for raising it. And I know your law does not cover data which is in transit through Mauritius. That was another point. Okay, right. So thanks for the introduction to Mauritius. And now we're going to turn our attention to South Africa, and introductions to South Africa from Lebogang. So please turn your screen on. Thank you. You're muted at the moment, so we can't hear you.
Thank you very much.
Thank you.
Stuart.
Now I can hear you and see you
very much, colleagues. Yes, I think we thank you very much for our inclusion as the regulator from South Africa on this webinar. And I think it would be very great for us to sort of impart knowledge and in terms of where we are as regulators in the broader as far as privacy is concerned. We, as the regulator, we are responsible for the Protection of Personal Information Act, which came into operation in 2013. We took office in 2016, chairperson and 4 members. Now, the act was promulgated in 2013, but the sections which came into operation then was just the definition sections, the sections that establishes the regulator, and sections which empowers the minister and the regulator to make regulations. Now, you can see that from 2013 up until when we took office, there was nothing in terms of enforcement power or anything that the regulator can do. However, on the 1st of July 2020, last year—
Excuse me, I'm going to interrupt to ask my colleague Khan to put up your slides because you have prepared slides. And so I think we're on slide 2 at the moment.
Yeah. 2, yes.
So can we turn to slide 2? Next slide, please. Right.
Yeah. Yes. Now, on the 1st of July 2020, the president passed a promulgation to the effect that the remaining sections of POPIA should come into operation. However, there's a provision in POPIA that there's a year grace period in terms of which private and public bodies should ensure that they put their compliance mechanism in place, which effectively means that POPIA will be in full operation from the 1st of July 2021. Now, as you know that we are responsible for both POPIA, which is the protection of personal information, and PIA, which is the promotion of access to information, which the president has promulgated that it will take effect on the 30th of June 2021. So our key dates there are the 1st of June 2021, which is PIA, coming into operation, and the 1st of July 2021, when POPIA will be in full operation. Yes, we do have sanctions in our law, both criminal and civil liability. Our fines are up to 1 million for breach of any conditions of the lawful provisions in terms of POPIA, or imprisonment, or both. Yes, indeed, we have gone through a lot of milestone and development to ensure that by come the 1st of July 2020, we are ready, 2021, we are ready to effectively discharge our mandates. We have, in the meantime, developed a number of guidelines that will ensure that public and private bodies comply with our act. For an example, we've developed the guidelines on code of conduct, on prior authorization, on the information officers and deputy information officers, on exemptions, on exclusions. We are looking at also trans-border cooperation, and also doing a guideline on direct marketing. So this is where we are in terms of an introduction as the regulator. We are just now ready for the 1st of July, when the act will be in full operation. And for the grace period that started from last year, July, which will end on the 1st of July 2021, we have been proactively encouraging public and private bodies to ensure that they put measures in place so that come the 1st of July, they are in compliance with POPIA. So Stewart, that's just the introduction in terms of where we are as a regulator in South Africa at the moment. Thank you.
Okay, thank you so much. Do you want to talk about the difference between POPIA and the GDPR, or is Sizwe going to look at that?
Hi, thank you. Thank you, Stewart. If you can just put up the next slide. So, you know, there's some key definitions that are different in terms of the POPIA and the EU GDPR, but in essence, there's a lot of similarity. So I don't intend to go through them vigorously, but in a nutshell, you know, the key principles or conditions, as we call them, is the accountability condition. I think that one is relatively straightforward. Then we have process limitation. Personal information must be processed in a reasonable manner, a lawful manner. The concept of minimality, in other words, only adequate and relevant and non-excessive information must be processed. And then obviously the fact that consent and the element of collection directly from the data subject. If we can have the next slide. So then we also have the purpose specification principle. That one is very specific. You know, it says if you take personal information for one particular purpose, you can't now, use it for a purpose that was not compatible with the initial purpose that you had collected it for. And then if you see condition number 4 there, it's quite related to purpose specific, but it specifically prohibits the further processing unless it is authorized by law or in terms of a legal obligation or a court order, or in the interest of national security, or if it is there to prevent or to mitigate serious or an imminent threat. There are also the exceptions regarding the processing of historical and research and statistical purposes. If you can just give us the next slide there as well. Then, the condition 5, which is information quality, I think is relatively straightforward. Information must be complete, accurate and non-misleading and regularly updated. I think I won't speak to that. Then the openness one is the one that I always refer to as the cookie provision. Because when I teach my university students, I always refer to the whole concept of cookies, to say cookies are the ones that notify you that a particular record may be processed, particular personal information may be collected. So in terms of that, the openness condition or principle, as I would call it, is also there. And then the last 2 principles, if we can go to the last slide on the conditions, is condition 7, which deals with the safety and security guards safeguards of the personal information. In other words, personal information once retained or once collected or used, and these are all parts of processing of personal information according to our definition. Once a responsible party, which you would refer to as a data controller, keeps personal information, there is now a positive duty regarding the securing of the integrity and the confidentiality of such information. It also goes a step further now, and it also says if there's a third party, which we would call a operator, in other words, a party processing personal information on behalf of the responsible party, then in that particular instance, our law now requires a written agreement that be signed, that the same safeguards be kept and put in place by the operator when processing the personal information. You know, with regards to that, there's the famous case of the Black Sash versus the Minister of Social Development in South Africa. It's a constitutional court case. I don't want to dwell too much on it, but you know, specifically in that case, the responsible party being the Ministry of Social Services, they were told that they must have specific things in place with the operator in terms of, you know, having a written agreement, and that they must protect the personal information of the data subjects. In other words, they can't just freely share it. So that really flows into the other conditions there as well. And then most interestingly, whilst we're on this condition, is the whole issue of data breaches. We've been hearing about data breaches all over. It's an international phenomenon. It's not just happening in South Africa, it's happening all over the world. But in terms of the POPIA, there are some self-reporting provisions there to the data subject as well as the responsible party. So therefore, you know, it really is a piece of legislation that has power. You know, it has power in the sense that it now makes sure that responsible parties are self-reporting themselves to the data subjects and the responsible authority being the information regulator in the event of a data breach. And the last condition, condition 8, data subject participation. I think it also speaks to a relatively straightforward, the fact that a data subject must still have control to either correct, delete, or you know, get rid of irrelevant or outdated information within the responsible party. So that, I think, deals with the principles, which are really not too far from either Convention 108 or the EU GDPR. Obviously, this is a 2013 piece of legislation. The regulator only became functional towards the end of 2016. So in terms of this piece of legislation, it will require some revamp in the next couple of years. You know, we haven't been as fortunate as Mauritius, who have really had a kickstart in this. And I wish to say this, you know, Mauritius really being a pioneer in terms of data protection on the African continent. But we are following, and the Data Protection Authority is there, and we will be showing that we have some teeth. I'll be giving over to Advocate Stroom again to just discuss one or two key definitions in terms of differences between the GDPR and the POPIA. Over to you, Advocate.
Yeah, and we can see some broad similarities between European law and South African law, even some different terms. You have operator rather than processor, data specification rather than limitation. So we can see that these are certainly in the mainstream. South Africa is in the mainstream. Sorry, Lebo.
Yes, true that. I mean, it's just the terminology, but I think they allude to the same thing. For example, a data subject for us is a person to whom the personal information relates to, and the responsible party is the person, any private or public body that processes personal information of a data subject. An operator is a person who processes personal information on behalf of a responsible party. A competent person is a person who's legally competent, or let's say, for an example, a person who can give consent on behalf of a minor child, then it should be a competent person. But I think more or less, even though they differ in terms of the name, but they allude to the same definition. I think that's it, Stewart. Thank you.
Yes, and also some observers, our very own Professor Graham Greenleaf, who's our Asia Pacific editor, is a privacy advocate and very strong advocate of privacy. But in many ways, he recognizes that the GDPR is very high standard. It's difficult to achieve, and it's better if many countries get up to the Council of Europe 108 Convention 108 standard, and this is plenty to be getting on with for many countries. Okay, let's turn our attention back to Mauritius. So Drudeisha, will you come back on screen, and we'll have the slides back from Mauritius. And the next point we got to was slide 6 for Mauritius, Khan. And here the question is, what are typical complaints you have received regarding companies? That are data subjects complaining about companies. What are typical complaints, and how have you been investigating them?
Yeah, just before I move on to this particular slide, I've seen all the questions regarding Mauritius, and I'll be able to answer all of them through the presentations. And if you still want to ponder on these issues, I will come back to them. So yes, definitely complaints that we receive at the level of the Data Protection Office are very wide ranging. And we do receive complaints against multinational companies operating in Mauritius. There are 2 main cases that I will be highlighting sometime after. And they relate to the data subjects access requests and disclosure of personal data. I will be able to talk a little bit about these 2 cases. But I just want now, next slide, to go to show you how we investigate complaints made by individuals who are the aggrieved parties in a situation. They are the ones entitled to make complaints to the Data Protection Office. I mean, as you can see here, it's very wide ranging. I have wide powers under Part 2 of the Data Protection Act, but the steps of investigation are very important. We make them file an official complaint online declaration forms, and it's like a police procedure. Statements are recorded, and then an inquiry is initiated by this office. And right now we have the collaboration of police officers posted at the Commission of Police. They collaborate with us when we cannot make site visits, inspections, etc., etc., and even recording of statements. They collaborate with us. And at the end of the inquiry, I give a decision. It's like a quasi-judgment. And any person who's aggrieved by my decision, if I decide to prosecute, to recommend prosecution, I don't prosecute just like that. I have to recommend prosecution. And if I recommend prosecution, then within 21 days, the person aggrieved can appeal to the ICT Appeal Tribunal. And this tribunal is actually, we've got many cases that have gone to the tribunal where I have decided to recommend prosecution. And the outcome of the investigation, now the novelty in the law is I added the amicable settlement of disputes, which is not arbitration, it's just mediation. That is, if we mediate the case, and if we come to a settlement, there's no need to prosecute, and both parties are happy. Otherwise, there is prosecution that can be instituted, but for prosecution to be instituted, it's a normal police procedure, and we need the consent of a director of public prosecutions to be able to prosecute, and it goes in the normal legal channel. And any fines or sentence are actually issued by the intermediate court here after hearings are done of parties. And the intermediate court is the middle layered court in Mauritius. We have a district court at the low level, then comes the intermediate court, and then the Supreme Court. So intermediate court is at this middle level, being given the penalty that is provided in the Data Protection Act, 5 years imprisonment. So it's the jurisdiction of the intermediate court. So you can see here, it's not only the Data Protection Office which is involved, it's also the police force, the ICT Appeal Tribunal, the intermediate court, and so it becomes a wholly legalistic, formal investigation. And that is how we do investigations in Mauritius. Next slide, please. Now I'm going to answer the question that I saw in Q&A relating to data in transit, the concept of establishment, and who are actually going to be registered in Mauritius before, as I highlighted. So as you can see here, Section 3.5 of the Data Protection Act, it applies to any controller or processor who is established in Mauritius and is not established in Mauritius as well, for those who are not established in Mauritius, but they use equipment in Mauritius and other than for the purpose of transit from Mauritius. Let me explain a little bit what this means. I mean, if you're not established in Mauritius, but you're using equipment for your business activities in Mauritius, other than just for transiting from Mauritius, which does not involve any activity then in Mauritius, if I'm clear enough, then you are considered to be established in Mauritius. So this is how we make that distinction applicable. So if you're not established in Mauritius, but you use equipment, then you have to nominate a representative in Mauritius for your business activity here. He's the one who is going to be incorporated. He's the one who's going to be registered with the Data Protection Office. And there are many multinational companies right now that have branches in Mauritius and are incorporated under the laws of our country. So the same way, domestic companies and those who are operating in Mauritius through multinationals, but having a representative here, they all have to register. So this is what I wanted to make clear. I think
it is clear. Yes.
That question here. Yes. Now I will give you some examples of the cases that I've been referring to, our investigations. Next slide. Next slide. Yes. There are two main cases that we, as you can see, one dates back to 2013. That is, we've had a long history of investigations, giving decisions since 2000, I think, 10 that we've started really giving major decisions. But this major case came in 2013, where actually the complainant was dismissed because she refused to provide her fingerprint for the recording of attendance. And we initiated an inquiry. We found that she was right, and the case went up to the level of the Supreme Court, and we again won after going to the ICT Appeal Tribunal and then to the Supreme Court. We won this case, and she was not required to provide her fingerprint, her biometric data for attendance in her company. And there is one other major case here, the cameras that have been installed in lorries carrying fuel in Mauritius. That's a major case right now. I have given my decision. I said, no, certain cameras are allowed outside, exterior view of the road and everything. But those cameras that are actually focusing on the driver, we said that it's highly intrusive and should not be put, even if it's a, it's a dangerous product, it's hazardous products being involved here. And we're still awaiting the decision of the ICT Appeal Tribunal. And so this is where we stand with this case. But it's a huge major case for us because we are relying on many international standards, including other jurisdictions like Canada, where we have seen some cases around. And next slide, please. This case is a very beautiful case. I think it's internationally a viable case as well. It concerns, I will go very, very quickly on this. It concerns the Mauritius National Identity Card Act and the fingerprints that are recorded on the MNIC, the Smart ID card for Mauritius. And this case, I will just give you a brief overview. It went to the Supreme Court, it went to the Privy Council, the Judicial Committee of the Privy Council, and now we just received a decision from the ICCPR Committee, where at this level, this individual who has refused to issue his ID card, he actually won his case. And it's saying that Mauritius has not been giving additional safeguards with regard to the Smart ID card. And that is a major case for us. And actually right now I'm sitting on a committee where we're reviewing the whole concept of the ID card, and there will be a new ID card very soon. I just wanted to highlight this.
Right. Okay, and this is interesting, and it shows that your office is independent of government because you are effectively criticising what the government's doing. Okay,
yes,
so thank you for that. And let's turn back to South Africa now to move on to the next stage. How regulators, so we went back to the slides for South Africa, and we're on to the next slide now. No, next one. Next slide, please. Right. And Lebo, so please.
Yeah. So thank you very much. How do we educate business communities? As you are aware, South Africa has got 9 provinces, and I mean your key ones will be your cities like Gauteng, which is Johannesburg, your Western Cape. But most of these provinces are rural areas. We understand that the private sector mainly operates in the cities, but we still need also to speak to our people who are conducting business in rural communities. Fortunately, we've got our education and communication teams, which is also trying to do those outreach programs to sort of educate both private and public bodies to ensure that there's compliance with the law. But you will note that we have noted that the private sector is very keen to comply. I've seen one of the questions to say, how are we going to ensure that the public sector comply? But the private sector is very keen to comply because it affects the bottom line. Whereas the public sector, which is mostly a municipality in terms of POPIA, there's a very low level of compliance. But the Act gives us the power to provide education by promoting an understanding and acceptance of the conditions of lawful processing, undertaking educational programs, and making public statements and giving advice. In terms of stakeholder, we every week we have a lot of stakeholder requests. So you find that in a month, every day we are busy with stakeholder engagement, whether virtually but because of COVID, we can't do on-person stakeholder engagements. But we are trying by all means as the regulator to ensure that we are out there, we do public statements, we are on TV, radio, all the mediums to ensure that Twitter, to ensure that we reach mass of our people to ensure that they understand their rights in terms of the Act. The next slide, complaints.
Yeah, what are the typical complaints regarding companies?
We receive a lot of complaints from especially against responsible party or private sector. The 3 main complaints that we receive are unsolicited direct marketing, section 69. Remember, our Act is more on the opt-in. I have to give a consent for you to give me marketing material. And if I say no, you have to stop. So it's still a problem in that understanding that you can, because I think previously this marketing people were making money out of this unsolicited direct marketing. So we have a lot of complaints on direct marketing, followed by any breach of personal information. For an example, you go to a particular responsible party for a particular service, but they then use your information to market another services within their organization. So the second one would be breach of personal information, and it's based on all the 8 conditions in respect. And the third complaints in terms of numbers that we receive, it's data breaches. They are increasing daily. And our approach is that we are on the grace period, and the question will be, what do you do with these complaints? Because the Act says you can handle them, but the Act is coming into operation on the 1st of July. And the question is that it's not the intention of the legislatures that POPIA should have a retrospective application. So we need to apply our mind as a regulator to say, what do we do with the complaints that we received during the grace period? And obviously the one that comes after the 1st of July, there are enforcement mechanisms in place. For now, what we do, we just encourage proactive compliance to say, no, we're handling it. We inform the responsible party that there's this complaint. Kindly make sure that it's just proactive compliance. There's nothing much we can do. But
so you encourage
compliance. Yes. So I think in respect of complaints, that's the 3 main complaints that we're receiving currently.
Right. So your law gives you plenty of powers, which you will be able to apply after the 1st of July. And the companies in South Africa have had plenty of time to get ready, because the law's been there since 2013, and the announcement of the 1st of July was from a year earlier by the president. So you're expecting a high standard of compliance once you reach the 1st of July. Right.
Yes, yes. And then the next slide deals with complaints, our enforcement powers now, in terms of how it's chapter 10 of our act. Section 4074 of our act provides that any person can submit a complaint in a prescribed manner and form, because we have regulated this in our regulation in terms of how you should submit a complaint to the regulator. And then the action that the regulator can take upon receipt of that complaint, we can either investigate, act as a conciliator, take action, or decide not to take any action, or refer the complaint to the enforcement committee. Remember, the enforcement committee is like a quasi-judicial tribunal within the regulator, where now a retired judge and expert will sit in the to ensure that some of these complaints we refer them to this enforcement committee, because previously in PIA, there were no enforcement mechanism. But then hence they say PIA didn't have teeth, because if you are aggrieved in terms of PIA, you can't even, you don't have any recourse. You just have to go to the High Court to appeal. But now, because POPIA is coming into effect to remedy certain gaps which were in PIA, now there are internal mechanisms that you can use before you can actually go to court. Meaning when we decide that we take the matter through internally through an enforcement committee, then the enforcement committee, if you are aggrieved again, will refer the outcome of the complaint to the regulator. And if you are still aggrieved by the decision by the regulator, then you can go to court. And again, what we can do, we can settle complaints, meaning we bring both parties and we settle the dispute between the two parties. We can also issue warrants. And that's the whole process that involves also, your court officials, your police. We can issue warrants of search and seizure, all those things. We can do them in terms of 82. And then if you are still not happy about the outcome of the regulator, that's when now you have the right to appeal such decision at the High Court. So there are actually internal mechanisms that are put in place for now that you ensure that we deal with this complaint properly. Other than a person comes and they complain and then they don't have any recourse, they just have to go to High Court, because litigation is also expensive. Hence, the Act came in to sort of find all those internal mechanisms to assist before you can actually go on a litigation route. And like I said, there are civil remedies available and sanction, obviously, ours is up to 10 million. And there's also imprisonment in addition to those sanctions. So it provides both criminal and civil liability. But I think it's good that, the Act is coming to full operation so that there can be recourse to our people whose rights have been violated in terms of POPIA.
So you've got several stages of enforcement. One that sounds a bit like the UK's Information Tribunal, that is your enforcement committee. And then if necessary, bring in the courts, but that's expensive. So you presumably will try where possible to resolve matters so people would not need to go to the High Court.
Yes.
Okay.
Because litigation is very expensive, yes.
Sure, and everywhere, yes. So that sounds a good graduated system where people can try and get satisfaction without going to court, which is the best way. Right, I think now we should thank you, Lebo, for that. And I think we now need to turn our attention back to Mauritius. So we can have the Mauritius slides again. And we're going to, the next section is how the data privacy law is being implemented by multinational companies. The next slide, please. Not that one, the next one. Next one, please. Yes, okay. Drudeisha.
Yeah. Okay, so I was browsing through the questions again. I would like to answer one question which is very interesting. Yes, if you are not established in Mauritius or you're not using equipment in Mauritius, but you're dealing with Mauritian data, definitely the Data Protection Act will apply. How? It's through Section 36 of our Data Protection Act. Basically, when there is a transfer of data from Mauritius to abroad, there are certain safeguards that are applicable in this context. And even if it's cloud-based or otherwise, that means anyone who is transferring data outside Mauritius, and it does not require a specific authorization straight away as a rule, as a matter of principle. But if ever there needs, you haven't shown that there are, appropriate safeguards involved, then definitely the commissioner will come into play, and we will ask you to show proof of appropriate safeguards before actually the data is being transferred from Mauritius to abroad. But there are, as you can see in that section, I won't be able to show you right now, it says that there are, let's say the data subject has given his explicit consent for the transfer to be effected. That transfer can be made. There is no need for authorization from this office. And it is necessary, for example, for contractual obligations, interest, the data subject, public interest, legal claims, vital interest, legitimate interest. All these are, in section 36, you can actually transfer data from Mauritius to abroad, but still the commissioner can actually ask you to prove that you are actually doing it adequately and appropriately. But most of our operators here in Mauritius, they choose to come to the data protection office. There is a form which is filled, and they show us actually how the whole operation is going to be conducted. And we give authorizations in most of the cases because they choose to come to us to ask for our guidance. And there is also a section in the Data Protection Act which talks about, when you are in doubt, you need to consult the office, you need to seek guidance from the office. So they rather go on this section, they consult this office, and they also submit the form for authorization, even though not in all cases they're required to do that. And it aligns with the EU GDPR as well. The problem is in Mauritius, as I said, it's not extraterritorial, it's territorial application, which makes it more difficult, unlike the EU GDPR, to actually apply across borders. So that's why we have different sections in the law which caters for different scenarios. But basically, to say you need to be incorporated in Mauritius for you to be actually subject to the Data Protection Act. That doesn't mean that the Data Protection Act will not apply if you're using Mauritian data for your own, like Facebook, like social media, etc., etc. So I just wanted to clarify this.
Thank you for that.
And yes, and if you have chosen a processor who operates in Mauritius, you need to have a contract with the processor in operating in Mauritius. They can be standard contractual clauses like any agreement, or they can also be binding corporate rules that you use to be able for your branches like multinational companies that you can use to actually regulate your relationship with the processor who is operating in Mauritius. And that is a perfect possibility. So this simplifies the whole scenario because then the processor is subject straight away to all the requirements contained in the Data Protection Act. So accountability here, we try to make sure that accountability is preserved and we are able to make the Data Protection Act applicable in almost any scenario. And in that regard, I will refer you to Article 14 of Convention 108+. We have become a party to this. We will be bound by it soon, which relates to trans-border flows of personal data. And there again, it's the same type of principles as contained in the Data Protection Act. There is no requirement for authorization from the Commissioner as a matter of rule, but as a matter of exception. And it's also the same type of provision as in section 36 of the Data Protection Act. Now, next slide, I will come to data protection impact assessments. There are two distinctions here. I will first talk about the DPIA, where there are high risks involved, the same as in GDPR as well. You need to have a data protection impact assessment. We have devised a template, as you can see down, it's on the website. We actually help you, you just fill in the form. and you submit it to us. We have many organizations, multinational companies who are doing it, and they submit it to us, and we provide our advice based on what information they have given to us. But it's only related to high-risk operations, especially multinational companies. Most of your activities are high risk, if not to say every activity that you do. So, but we have also published a list of criteria for you to be able to distinguish what is actually high-risk processing. And you can see on the slide here, evaluation or scoring personal aspects, profiling, automated decision-making, systematic monitoring like CCTV, sensitive data, special categories of data, large-scale processing, matching, data on vulnerable people, innovative use, AI, etc., or when the processing prevents data subjects from exercising a right or use of a service or a contract. So very widely elaborated high-risk processing operations by our office here. And we follow these principles to ensure that actually when you're submitting the DPIA, you're actually relating to one or more of these criteria here.
Yes,
And
I'll interrupt to say that your documents are very informative, very useful, and you do explain exactly what companies should do. So I congratulate you on the clarity of those. Can you now move on to the next slide, certification, a few words on certification before we move back to South Africa.
Okay, yeah, very important as well, certification. We are actually a certifying body, and we certify all controllers and processors who want to be certified. It's not mandatory. You have the choice, and it's free, and it's a validity period of 3 years. We can actually withdraw the certification if we think there is a problem with yours, with your certification. There is a document here on our website, which again, you just fill in the form, and we come and visit, and we make audits, and then we tell you whether we can certify you or not. And that is something that I highly recommend, because it actually really helps you in understanding the Mauritian Data Protection Act, and it makes your life very much easy. So thank you, Stewart.
Okay, so I think what we should do now, we are say running rather late with a few minutes. I think what I propose to do is extend this by 15 minutes, because we want to go back to South Africa, and we also need to talk about international transfers. So as we're fully engaged in the discussion, I propose we say carry on till another 17 minutes, because we've got much to cover. So let's go back to South Africa, and let's talk about how data privacy law is being implemented by multinational companies. So can we have the slides back, South Africa slides?
Yeah, thank you. The next slide. Thank you very much. Ours is section 72 of POPIA. It provides that a responsible party in South Africa may not transfer personal information about a data subject to a third party who is in a foreign country. So it's no transfer unless the following. I think they're similar, more or less similar with the one in Mauritius, unless a third party who is the recipient of the information is subject to a law, binding corporate rules, or binding agreement, which provides an adequate level of protection that effectively upholds the principle for reasonable processing of personal information that are substantially similar to the conditions for the lawful processing of personal information. So it means if you're transferring personal information to the GDPR, to the UK, you must make sure that the GDPR has the same level of protection as in POPIA, or they are substantially similar. So I think it's the same as with the Mauritius on this one. Or it must also include provisions that are substantially similar to this section relating to further transfer of personal information from the recipient to a third party who is in a foreign country, or if the data subject consent to such transfer, or if the transfer is necessary for the performance of the contract between a data subject and the responsible party, or for the implementation of a pre-contractual measure taken in response to a data subject's response, or if the transfer is necessary for the conclusion or performance of a contract concluded in the interest of a data subject between the responsible party and a third party. Or lastly, if the transfer is for the benefit of a data subject and it is not reasonably practicable to obtain the consent of a data subject to the transfer. And if it were reasonably practical to obtain such consent, the data subject would likely give it. So if you transfer, you must also meet all these requirements. So the Act provides you that the general rule is that you cannot, but there are exceptions. And if you meet those exceptions, then you can transfer. Thank you.
Thank you. And yes, these your slides, there are several more slides on this question. And I remind everyone, the video of the recording of this video and the slides will be available from tomorrow. So you can look in detail at those points. So let's go back to Mauritius to talk about the progress of discussions with the European Commission on adequacy declaration for Mauritius.
Yes, Stewart, we are very happy to announce that we have started negotiations with the European Union, and the EU delegation based in Mauritius advised us to have a consultant. And we are right now in the process of nominating a consultant to give a report on the data protection ecosystem in Mauritius. And I guess by next year, we'll be producing that report, and we will submit it to the EU data protection authorities there. And the time that it will take for the EU to come back to us will be just for the EU to decide. It's not for us. But unlike Convention 108 Plus for us, which went very quickly, I must say it was marvelous. I hope that for the EU adequacy as well, it goes as quickly as with Convention 108 Plus. But I certainly cannot vouch and say what time limit, what time frame the EU will take after us submitting that report as to 1 year or 2 years. So basically, I don't have an answer for this. But this is going to be for the EU adequacy. And now Convention 108. Next slide, please. It's very important for us to focus on this. As you know, Mauritius is the first country in Africa since 1st of October 2016, when it actually signed and ratified the first Convention 108. And we were, again, the first country in Africa to have done that. And again, in September 2020, the first country in Africa to have ratified Convention 108 Plus. As you know, it's still in process. It's not yet into force. They're still awaiting the required number. So the ratification of this convention, Mauritius is preparing itself. That's why we also made the new Data Protection Act. It's basically Convention 108 Plus reproduced, if you look at the new Data Protection Act, but we have other layers of Mauritian spices and ingredients in our Data Protection Act, like any other country would do. But basically, all the principles in Convention 108 Plus are ingrained in the Data Protection Act. And that's marvelous, because we won't have problems with implementation of Convention 108 Plus. But we made a suggestion. I mean, I think once many African countries, let's say, have ratified this convention, we suggest that there are free transfers of personal information between these countries who have ratified this convention, because we are all bound by the provisions of this convention to facilitate cross-border data flows. That's one way of looking at Convention 108. And the other way is the EU GDPR. EU adequacy will actually achieve this purpose again for the European-based companies, because we will be able to make free flow of data possible without any hampering problems. So that's what we're aiming for. And I just want to highlight at this point that Mauritius is actually the first country in the world which made this Data Protection Act on 15th of January 2018. That is some months before the EU GDPR in May 2018. It's just that we were preparing also. We were trying to be proactive with regard to EU GDPR as well. And with Convention 108 Plus, it's the same scenario. So we are quite lucky in that way, even just before UK as well. UK Data Protection Act came into force, I think, in May or something, in 2018. So we were actually a precursor in that area. and we did that. We made that happen. Next slide, please. Yes, I just want to tell you that we form part of many such networks here, as you can see. International cooperation is actually a legal requirement, one of our functions provided in the Data Protection Act. I have to cooperate with other supervisory authorities across the world. And that's also enforcement-wise very important, because when we have investigations, we do cooperate with other data protection authorities across the world. When we cannot actually ourselves initiate the inquiry, we collaborate, we cooperate, and we make inquiries happen. Let's say we have Mauritian data being, processed in Ireland, and we are not being able, through Mauritian, companies here or organizations trying to get hold of those who have contravened the Data Protection Act. We actually liaise with the UK Data Protection Office, the ICO, or any other island, for example, and we collaborate with them and we make inquiries happen. So this is how we're working right now. We did it for Cambridge Analytica, and we are going to do that again for the major Facebook, hacking problem that just happened. So basically, this is what I have to say. Now, the questions and answers, I'll be available to answer all of them, unless Stewart, you have some questions for me.
Well, thank you, Commissioner Drudeisha Madhub. We must turn back to South Africa because they haven't finished yet. And I just had an idea, we've got so much material here. We were thinking that perhaps we should have some kind of follow-up round table where people can put questions. There are many questions which are in the Q&A which we will not have time to deal with. So we'll write to all participants tomorrow to see who is interested in some follow-up roundtable where people can exchange experience on their dealings with both jurisdictions. Right, let's go back to South Africa. And which of you will continue now? Is it Lebo or Sizwe?
Professor.
Yes.
Right. Okay.
Sizwe.
So
we want to talk about international transfers and links between South Africa and other regulators. Unfortunately, I can't hear you. I don't know.
There was an inquiry about,
right.
as relatively straightforward. You can't hear me?
I can now. Please go ahead.
Oh, okay. I was saying the situation of the information regulator is a unique one, because of the fact that we also deal with access to information. So we've got several linkages around the world, be it through the common thread, be it through the Global Data Protection Network, or also the RADPA, which is the Roundtable of African Data Protection Authorities. And like I said, we have this dual mandate, and South Africa is currently also the chair of the Network for Access to Information network as well, as this is the other mandate that we have. So, from a regulatory point of view, we're very strong on collaboration, very interested in seeing what other regulators are doing in terms of hot issues. I can't necessarily share what the specific issues are, but we've been seeing there's a lot of issues regarding social media. So even that is not just something that the South African regulators worried about. I think regulators all over Africa have now followed Q as well, and are also concerned about how some of these electronic service providers, in particular social media companies, use our personal information. So very, very strong linkages on the African continent, not just the Francophone region, in other words, not just West Africa, but we've been seeing also on the East African side, Kenya coming very well there as well. I see one of the smaller countries there as well, and Tanzania following suit. So I think even from a SADC perspective, all the countries around South Africa, be it your Namibia, be it your Zimbabwe, be it your what's this other country, Mozambique. All of these countries have literally followed cue from what South Africa has done from a data protection perspective. So there's definitely a lot of collaboration going on there. Next slide. Right. I guess the slide on the screen now also speaks to what I've just said now, to say that, you know, it's not just on an international level where we collaborate. For instance, when we had the Experian data breach, during the course of our investigation, we were made aware of the fact that some of the information had landed on a server in Switzerland. We gave contact to the authorities there as well. So it is really not an isolated initiative by the information regulator in South Africa. We are really trying to join hands with all the regulators around the world to try and avoid the abuse of personal information on all levels. If you can just give me the next slide there. Okay, well, I think this is just a reminder for everyone. I know Advocate Stroom did mention it already, but as of the 30th of June, 2021, you know, the POPIA will be fully inactive. So the grace period that we've had now as of the 30th of June, 1st of July 2020, that is a period for people to get their houses in order. I always say it's not a grace period to continue being ignorant of the POPIA, to continue breaking the POPIA, to run to your attorney and get your attorney to get you out of trouble. No, that is not what the grace period is about. The grace period is a period for people to learn, to understand that it's a new legal regime. It's a new way of processing data. And in this period, people must try and become compliant, as there will unfortunately be sanctions and administrative fines if there are complaints or the regulator initiates investigations on its own behalf. Next slide. Okay, so just to set out quickly, the sections that were previously not enforced were sections 2 to 38, sections 55 to 109. So 2 to 38 is primarily the scope and application of the Act, the exclusions, the 8 conditions that I referred you to, as well as the exemption clauses. From 55 to 109, it's the situation regarding information officers, the codes of conduct, prior authorization, as well as the complaints mechanism as to how you can bring a complaint to the regulator and how it will either be adjudicated or not adjudicated. And then just very interestingly as well, the powers from the South African human rights relating to the PIA, the protection of access, the promotion of access to information act, those functions will now also be moved over, and the PIA has been amended to the extent that a similar dispute resolution mechanism, such as the POPIA, has now been put in place in the PIA as amended. Next slide.
I think, Sizwe, that we're pretty well to the end of our time, or even over our time. And I think what we need to do is have a follow-up session, perhaps focusing solely on South Africa, because you have so much new material. And if we could arrange a follow-up session, then we can deal with these importance of where you investigate data breaches and the other material which you've prepared. So you have many slides with much very useful information, but I'm concerned that it's rushing you too much, and we should try and finish. I know Laura's here, and I expect you're telling us about, I can see that we've had more questions for this session than perhaps all the previous sessions put together. There's incredible level of interest. So what we'll do tomorrow, we'll write to all participants and speakers and float the idea of a follow-up roundtable where people can just put questions as questions and answers. Will perhaps consist, the whole session will be questions and answers. And I think that will be a good way forward. And then there you can deal with these other points that we've not had time for.
That's fine, Stewart. The only thing which I do want to mention, if you don't mind, is the second paragraph of the slide.
Yes.
Actually extremely new news.
Right.
I think it's for the first time that we're publicly actually saying
right.
that the preliminary report regarding the Experian data breach has now been received by the independent consultant that the regulator had asked to do an investigation, and it will be shared with Experian and then obviously the public in due course. So I just thought I need to address that one.
Yes.
Because it is new news, and I've seen from your participants, people from the Republic of South Africa are present.
Right. Yeah. So we could certainly go into that in more detail if we run a run a follow-up roundtable, which we would invite you to participate in. So Laura, I think that's the best plan forward. I suggest we have a concluding statement from Mauritius, and then we'll call it to an end. So Drudeisha, would you like to make a concluding statement?
Yes, very quickly. I know time is a constraint. It was actually, I think it's very important to highlight also that, for one question, that every organization in Mauritius needs to appoint a data protection officer. It can be anybody in the organization, but it has to be someone who has this title, data protection officer. Otherwise, that company may be prosecuted by the Data Protection Office. So this is making very huge, waves in Mauritius right now, and people are not understanding that, yes, we need to have one person in the company, in the organization, who is called Data Protection Officer. I wanted to highlight this point. And then just to conclude, to say that Mauritius, as you know, is a leader in Africa on many economic aspects. And we are definitely trying our best to make sure that the data protection landscape in Mauritius keeps on improving day by day. And that is my main motivation. And thank you so much for this.
Well, thank you. Would all speakers come back on screen, please? We'd like to see you all to say, to thank you all. So Sizwe and Lebo as well. So yes, we've covered a lot of ground today. We thought we could do it in an hour, but that was impossible. A lot of material, and we will provide the slides and the recording. And I say we've had so many questions that we really should have a follow-up roundtable, which consists mainly of questions and answers, because we've covered that. And we'll discuss with you offline when that should be. But it could be quite soon, because this information is now fresh in everyone's minds. So I'd like to thank you all. I've tried to achieve a balance between the two jurisdictions. So I hope you've satisfied. I've done my best to achieve balance there. So thank you so much, Commissioner Madhub, Advocate Stroom-Nzama, Professor Sizwe, and really appreciate you joining in with full hearts, with as much discipline as possible to kind of cover the ground. But we think this comparison was a good idea, so people could see the differences between a well-established jurisdiction and one which is moving forward fast to catch up. But South Africa, of course, very influential in the region. And I noticed that we have other commissioners attending this event. So there are a lot of eyes on South Africa. And we will have other events in which we include Africa. We already did actually have one which had Egypt and Nigeria. That was a few months ago. So we will continue watching this region indeed. So thanks to you. And finally, I'll say we have other events coming up on 13th of May, Jersey, Guernsey, and the Isle of Man, and the UK, of course, data flows. On 18th and 20th of May on Asia, new and updated privacy laws in Asia, with our Asia Pacific editor, Professor Graham Greenleaf. And on 26th of May, an event sponsored by Dentons on doing business in China, how to navigate Chinese data privacy and cyber law. So on behalf of myself, Laura, Laura Lincolmis, hope you and our families keep safe in the face of this horrible pandemic, and we will keep you informed of future events, and we'll work together to get a roundtable organized. So thank you very much, everyone. And by this was the best attended event we've ever held. So you should be proud that you've attracted a lot of attention. So thank you all so very much. And that's all for today, and goodbye.
Goodbye. Goodbye.
Bye.